So, guess what? The Second Circuit made a bad decision, and we're going to talk about it right now on John Crump News. What is up, everyone? I am John Crump, and this is John Crump News, where we talk about everything gun-related. And I am joined by my co-host, the guy that co-hosts a lot of my shows. He is the Flying Run, Blind Rich. And Rich, I appreciate you, bud.
I appreciate you, Crumpy.
All right, today we're going to be talking about a case that, the case was filed, it was appealed in August of 2023.
That's post-Bruin, right? Or no?
Post-Bruin. Yep.
Post-Bruin. Okay.
It was argued on January 30th, 2024.
Mm-hmm.
And we got the decision today.
Wow. They thought about that long and hard, or they just rolled the dice and said, okay.
A slow roll. That's what they do. And we're going to be talking about it. It is Fry versus Ching.
Not familiar.
Of course you're not. Just like you're not familiar about Dark. Yeah, let's go ahead and bring it up. It's the TLDR, in case you don't want to stick around, is the preliminary injunction against the CCIA provision of carrying a firearm in Times Square has been rejected. A district court did reject this before, but they rejected it, saying that the plaintiffs had no standing to sue. The circuit court said the plaintiffs do have standing, but they're still it's still not a-okay. And one of the interesting things that I see in this case, which I've seen in a lot of cases, is the historical analog being used to okay the ban of carrying firearms in Times Square is laws from Northampton. Northampton is where, Rich?
Is that Virginia? Oh, Northampton. Huh. Hampton. Places called Hampton, I think, started out in England.
Yes. But I've seen this law being referenced in other cases.
Do they just get a deck of cards? It's like, hey, man, try this one.
Yeah, well, they pull it out. Which also the Northampton law is from the 1600s too. So, you know, they say in Bruin, it says that farther a law is away from the founding, the less it's worth. But the Second Circuit, for some reason, likes to exclude laws before the founding of the country.
Look, they're going to see if they can make something stick. Correct. They're going to throw crap against the wall, and if one thing sticks, that's going to be the gateway drug.
Correct. So this is in front of a 3-judge panel. Let's go ahead and read this.
Plaintiffs, appellants brought pre-enforcement Second Amendment challenges to certain aspects of New York or New York State concealed carry license regime as a result of the appellate plaintiff's challenge the constitutionality to prohibit on carrying firearms in sensitive locations, namely Times Square, New York City, subway system, Metro North, New York penal law, blah, ban on open carry.
Yeah, okay, we can stop right there. Basically, New York, under the CCIA, requires individuals to obtain a concealed carry permit to carry a firearm, but they made a lot of the state-sensitive areas.
But, all right, so Clarence Thomas must have heard some rumblings that this was going to be their play.
Yep.
And in the Bruin decision, Thomas said, yeah, that don't fly, homie.
Well, one of the things that Thomas did say,
and that's an exact quote,
is that you cannot ban the carrying of firearms in a place by declaring it as a sensitive area if it's just because that's where people gather. The CCIA banned carrying of firearms in Times Square because that is where people gather, which is a direct thumbing the nose at what SCOTUS said. So, Jason Fry is a friend of the channel, by the way.
Oh, cool.
He is a viewer and a reader.
So who's the lawyers in this case?
I don't know the lawyers offhand. I just know Jason.
Okay.
Jason and his wife were on this case.
We review the denial of a motion for a preliminary injunction for abuse of discretion, which we will indefinitely will identify only if the decision rests on an error of law or clearly erroneous finding of fact, or cannot be located within the range of permissible decisions. And their cite case law is, we may, of course, affirm on any basis for which there is a record of sufficient permit conclusions of law, including grounds upon which the district court did not rely. I don't even know what any of that means.
It means that unless there's something egregious, they're not going to overrule the judge.
Oh. Preliminary injunction, extraordinary remedy.
Yeah, you don't treat that.
Yeah, it isn't.
Then it goes into the right of the people shall not be infringed, and if it highlights the Bruin two-step framework, and it's going to quote Rahimi here. Basically, the two-step framework is looking at the plain text of the Second Amendment. Is the conduct covered? The right to bear arms. Arms is guns and knives and anything else bear. And if guns are bearable, then that is covered as long as they're not dangerous and unusual, which I don't really like. But a handgun is not particularly unusual. And the people refers to those of the political class which have reached the age of the majority in the United States, which is 18. That's the first step. That is on the plaintiffs to prove, and they did that. The second step of a Bruin framework is to look at the law and see if it's consistent with the nation's tradition and history of firearms regulations. So here, so if you look at that, you do that by using analogs from the founding era, which most people agree
in this country
is 1791. Now, an analog does not have to be a dead ringer for a law, but it has to be similar to a law. That's being challenged to show that that law is consistent with the text and tradition. So that's what this is going to say. It just explains Bruin here.
Funny, did they skip the part about where people assemble in Bruin?
Yeah. And they also point out 1868 here. So they're trying to use 1868 as well. That's the ratification date of the 14th Amendment, which said, yes, the Bill of Rights do apply to the states. And when they did apply to the states, that is the founding era, which I totally disagree, because the 14th Amendment did not extend the right. It's saying it was verifying, yes, it does extend to the states. It's not changing anything. It's just clarifying the states are not immune from the Bill of Rights. Now, the reason why there was a lot more gun laws in 1868 that popped up around 1868 was the Civil War just ended and we entered into the Reconstruction period. During the Reconstruction period, there was a bunch of gun laws passed known as Jim Crow laws. These Jim Crow laws was to prevent formerly enslaved people from getting firearms and taking their...
Or can I just say, prevent the Democrats who were lynching the freed people from getting shot at.
Yeah. Basically. So there you go. And this is interesting. Reed in particular. Sorry.
In particular, Heller underscored the importance of Reconstruction-era evidence. Heller explained that in the aftermath of the Civil War, there was an outpouring of discussion of Second Amendment in Congress and in the public discourse, and those born and educated in the early 19th century faced a widespread effort to limit arms ownership by a large number of citizens. You mean they were racist?
Black people, yeah. And it actually goes into that, but they lean in on it.
And again, saying we can do this because we once were racist probably isn't a good argument. I'm not sure why Democrats keep going there.
Because it's the only thing that they have.
And maybe they're racist.
All right. Read this from here.
Where there is no strong historical evidence from the founding era, it is appropriate to look toward and rely upon later historical evidence. As we articulated in Antioch, the paucity of similar historical regulation during the founding era does not evince a lack of historical tradition in the nation's whole tradition.
Okay, basically what they're saying here, if we can't find a law that matches,
we can make crap up.
We can push it out to find until we find a law.
But they're wow. To unpack that phraseology would I could write a thesis on that.
All right, read this.
As discussed above, looking to later history in the face of intermediate founding era records fit neatly within the originalist and liquidation theories espoused by the court in Heller and Bruin. It comports with an originalism analysis pegged to 1791 because Reconstruction era evidence, though secondary to founding era evidence, nevertheless uniquely instructive to understanding the original public meaning of the Second Amendment right, since those born and educated in the early 19th century faced a widespread effort to limit arms ownership by a large number of the black slaves that were freed during the time period. Heller, let's see, U.S. blah.
Yeah, basically what they're doing is citing, well, people were alive.
They were alive in 1791 and in the 1800s.
Yeah.
And because we're racist and prohibited blacks from having guns, we should be able to do this also. Wow.
And that goes in the sensitive areas. We know what Thomas said about sensitive areas because we already went over that.
The district court found that plaintiffs satisfied requirements.
You don't have to read this.
Okay.
Yeah. Okay, so it talks about how they can restrict firearm carrying in sensitive areas.
You want me to read this?
No, it's just gonna. So they're saying that what they're trying to do is, I just want you to note here, Northampton, 1328.
And didn't Xenu have something against carrying of guns, like in the founding era on his planet?
I don't know, but they're going back to a law from 1328.
Yeah, that's founding era-ish.
We're closer to 1791 than 1328.
And Coop, a first grader, could, I don't know what the rest says, but
yeah, we're closer to the founding era than 1398. Most of Europe, with the exception of probably the Vikings, didn't even know that there was a North America.
They just knew it was a cool vacation spot.
Yeah, so yeah. Read this right here. Texas law.
Texas law, in noting the Second Amendment, does not guarantee the right to carry upon his person or any of the mischievous devices inhibited by the statute to a peaceable public assembly, for instance, into church, a lecture room, a ballroom, or any other place where ladies and gentlemen are congregated together.
Now, look at this law is from when?
1886?
1886.
Hmm.
Which is not only not close to 1791, but it's not really close to 1868 either.
Gee whiz.
So this footnote, let's go ahead and read this footnote. Footnote 6. It's interesting.
We are not so certain that the Northampton statute or the Virginia and North Carolina laws that replicated it prohibited carriage altogether, as Antioch acknowledged the Virginia state prohibition conduct not simply carriage, bearing arms in terror of the county. Although Antioch read the Northampton and North Carolina statutes to have prohibited firearm carriage in general at fairs and markets regardless of conduct, Bruin undermines that interpretation, as Bruin explained English courts interpreted the Northampton statute to do nothing more than affirm the common law offense of going armed to terrify the king's subjects, and therefore one's conduct will come within the act only where the crime shall appear to be malo amino.
Brandishing is what they're talking about.
By the 18th century, the Northampton statute was no obstacle to public carry for self-defense in the decades leading to the founding, because as one widely read 1760 treatise confirmed, no wearing of arms is within the meaning of the statute of Northampton unless it is accompanied with such circumstances as are apt to terrifying the people. As to
yeah, you can the rest is just going on that. So basically, they undermine the law. They've basically saying, well, this is what it means. It's talking about brandishing.
Okay.
But then they still concentrate on that law to say that they have constitution. It's constitutionally.
That's like being a little pregnant.
Yeah. All right, read the plaintiff's focus.
Plaintiffs focus on lack of a distinctly similar historical regulation directly addressing firearm carriage on public transportation is misplaced. Appellants reply, there were no mass transit systems at the time of the founding, so the lack of historical laws that specifically regulated transit systems was a natural consequence. Notably, the first railroad in America was not built until 1827, and the golden age of railroads began around the Reconstruction era.
So they're trying to say that what they're trying to do here, this is tricky. They're saying, well, there was more trains during the founding era than when they first started in like the 1820s. So therefore, the best time period to look to would be the Reconstruction era, which gives them an out because of why, Rich?
Because they have nothing during the regular time, and of course the Reconstruction era was when they wanted to make sure the slaves wouldn't shoot back at the people trying to lynch them.
Yeah, but here is a cool thing right here.
Accordingly, the district court erred in concluding that the plaintiffs lacked standing to challenge the open carry ban.
Okay, this is a good part, because originally the district court said that the plaintiffs did not have standing to challenge the ban, which means that the district court didn't have to consider anything, because if there's no standing, they don't have to look at it at all. But
Now, this court, doesn't Thomas oversee this court? Thomas?
Second Circuit? No. I think it's Sotomayor.
The wise Latina.
I think it's either Kagan or Sotomayor. I'm pretty sure it's
One of the wise Latinas.
Let me just verify that. Yeah, Sotomayor. However, I just wanted to make sure. Yeah, Sotomayor oversees the Second Circuit.
Can Trump just appoint another justice to replace Sotomayor right now?
No, that's not how
Because that's what Biden did before. Who was it that retired? Biden appointed Tarzan Jackson before. Was it before the one retirement? I forget who it was. Kennedy, yeah.
Yeah. Oh. Yeah. So, basically, they ruled against Jason and his wife and William Sapp. I don't know who that is, but I am sure they're going to ask for a en banc hearing. An en banc hearing is when the full bench will hear the case. So instead of being in front of a panel, it'll be in front of eight judges. What happens at that point is the panel's decision is vacated. It's like it never happened, and it is a do-over. Now, I want to caution people, even though they ask for an en banc, which I'm sure they're going to do, there is no guarantee that they will get an en banc. The court can say, nope, we're not going to grant an en banc. What they can also do if the en banc is denied, or they can just go directly to the Supreme Court of the United States. They can file,
which could take years.
It's called a writ of certiorari. So that will go to, well, either way, we're at least a year away, probably more, from having this case settled. So that is the next step. But the Second Circuit isn't the most gun friendly, so this is not a real big surprise that this happened because they're not gun friendly. Now, a lot of people think that Ninth Circuit is the worst circuit for gun rights, and the Ninth Circuit is not the worst circuit for gun rights. It's up there, but it's not the worst circuit. The worst circuit for gun rights is definitely the Fourth.
Where is the Fourth?
Virginia, Maryland, Delaware.
Wow. And Florida is probably one of the worst wild cards, the gunshine state that is kind of allowing open carry right now. But Virginia, I'm very surprised you guys have all sorts of carry rights, except you couldn't sell dark a gun without going to an FFL.
Yeah, but if you're under 18, if he's under 21, I could. I'm serious.
Wow.
So this was the makeup is 2 Republican judges and a Democrat.
2 Republicans and so it's just like the Florida State House.
Well, both of these judges were appointed by George W. Bush, not Trump appointees.
Well, and the thing about this is because a judge is appointed by a particular, let's just say a Republican president, it doesn't mean it was part of horse trading.
Delaware is in the 3rd, sorry. Well, it's Maryland, Virginia, West Virginia. Yeah.
Wow.
I think the Carolinas, I believe. But yeah, the 4th is terrible. But one of these cases, I think Antioch will get up to SCOTUS before this. So we'll have to see. Rossman Clippy?
Yeah, you're not following along with Louis Rossman.
Yeah, I know what you're talking about, but
I was just wondering if Ron Bear is a Rossman Clippy.
okay. All right. But yeah, that's basically it. Just wanted to make you guys aware of what's going on here. Yep. With that, we are going to get out of here. Thank you so much. And yes, that is it.